Good morning and welcome to the new edition of Dr. Lamba's Awakening Call. India's Supreme Court and other courts are curious animals. We have examples of excellent judicial minds, impartial, objective, and incisive. And we have absolutely mental retards, people who can recommend that a raped girl marries the rapist. Anyway, as I said earlier in one of my comments, that the biggest problem is when judicial activism becomes almost insufferable and the courts try to assume the functions of judicial as well as of the executive. And that should never be done. But the worst thing is when they want to take action based on the concept of suo motu or PIL, public interest litigation. Now, these two concepts are valid when there's absolute exercise of judicious mind. But many times we have seen that the justice, in a personal sense of resentment or personal involvement, invoke and call for suo motu action, which should never be done. As a matter of fact, suo motu denotes two things. One, that the judges are overseeing the judiciary and the executive, and that's not their job. Their job is to interpret laws and see that the laws are being understood properly and the people are not suffering because of misapplication. But they are not ombudsmen. They are not overseers to see whether the laws are being implemented or not. That's the job of the executive. Secondly, PIL. We have seen a plethora of public interest litigations. And although a small minority of those are really relevant, but the majority of them are either politically oriented or have an ulterior purpose. As a matter of fact, even the Supreme Court itself admitted that they take a lot of the court's time and are at the most, a diversion. But should that be permitted? Anyway, the latest is the Supreme Court's acceptance of a public interest litigation which challenges the validity of a law passed in 1991. Now, the beauty is that just 2 months back, 2 years back, sorry, in 2019, the Supreme Court itself had praised that law, high praise. And that law basically was a very valid, reasonable law because it applies ointment on the lacerated soul of the nation, which was on the verge of being divided. At that time, the Ram Janam Bhoomi Babri Masjid dispute was at side. Babri Masjid had been destroyed. And there was a danger that the country might be engulfed in communal rights. So this law was enacted called the Places of Worship Special Provision Act. And now, after praising this, the Supreme Court has sent a notice to the central government why it should not be re-looked at. It is reopening of the healed wounds. It's unfortunate The law was to prevent conversion of the religious places and maintain their religious character as it existed on August 15, 1947. Exception was for Ayodhya, Ram Janambhoomi, and that too because the case was already in the courts. And the Supreme Court, when it took a decision, awarded the disputed land to the Hindus for construction of Ram Mandir, stated that the law addresses the separate state as much to every citizen, and that its norms bind those who govern the nation at every level. Now, this law has been challenged by a PIL, and the Supreme Court judges have accepted this process and they arrogate governance and bog down the judiciary. And this matter is neither a constitutional matter, it's not against the constitution, it's not ultra virus, and the courts are only to decide the matter about a law being against the constitution. And since 91, everybody has praised the law. So why raise it now? Secondly, it doesn't harm anybody. And the petitioner has approached that this cut-off date of 15th of August is arbitrary, irrational, and retrospective. Suppose it was 16th of August, the 15th. Would it matter? No. But the purpose was that the 15th of August, 1947, is a historical date when India got freedom. And the British system was supposed to come to an end. So that's why the reason of the cutoff date is there. There's nothing sacrosanct. It could have been 14th of August, it could have been 16th of August, it could have been the 1st of January 1948. Immaterial. But to call it irrational, call it arbitrary is absolutely not acceptable. And then, the objection is that the law prohibits Hindus and others from approaching courts to reclaim places of worship. And now comes a very interesting word, invaded and encroached upon by fundamentalistic, barbaric invaders. Whether they were barbaric or not, whether they were fundamentalist or not, is not a matter for the courts to decide. That is a cultural issue, that's a political issue. That historically might be right, might be wrong, there can always be two opinions. As I discussed the other day, that the truth has certain diverse variations and that diverse interpretation, what is true to one may not be true to the other. The petition itself is guilty of very arbitrary and irrational arguments. And I'm amazed that the Supreme Court religiously accepted the petition. And the judges were so involved that they issued notices to the government of India. They forgot that it was August 15, 1947, that India became a modern secular country. Much of the ancient and medieval history was barbaric. Now let's be very clear. When Ashoka became Buddhist, and even after becoming Buddhist, was he not barbaric? He became a king after killing 100 other claimants. So that was barbaric. Battle of Kalinga was so barbaric that he himself reversed. Was even in our epics, Bhim rather, opening the chest of Dusashan and drinking blood. Was that not barbaric? So barbaric attitude were there at that time. It was a norm. But they are there today even, where you lynch people, when you kill people. Is that not barbaric? What happened in 1947 when millions of innocent people were killed and women raped? Was that not barbaric? Was 1984 when 4,000 Sikhs were killed in Delhi, not barbaric. Wars when 36,000 Hindus were killed in Punjab by the Khalistanis, was not barbaric? So barbaric is a part of life. And at that time, it was much more accepted than it's today. But the modern republic cannot retrospectively entertain grievances which have been lost in the mist of time. You cannot always keep harping to that. That way, quite possible tomorrow you can say that at one time, an Indian king, Bapul Rava, who had defeated Qasim, had gone up to Iran and had conquered Iran. So Iran was a part of India. So say, no, we go back to the history and right up to Iran, that should be a part of India. That means Pakistan, Afghanistan, and Iran. They should be part of India. Can anything be more ridiculous? You cannot be stuck in 670s or 10, I mean, say 1,000 or whatever fear it is. And you cannot undermine the constitution predicted upon the rule of law to correct history. The job of the constitution, the job of the Supreme Court is not to correct history, it's to correct laws. So the ipso facto, the petition was wrong, and it was wrong on the part of the Supreme Court to just accept, to excite Hindus, to encourage them to be more proactive, to take over the temples which were converted into mosques. And once you start doing it, there's no end to that. There were at least 500 mosques in Punjab alone, which were taken over by the refugees in 1947. They had no home. I don't blame them. And these mosques had been deserted. The Muslims had left for Pakistan. So the refugee families came and entered them and made them their homes. I know some of them were converted into gurdwaras. Would you go back in history and reconvert them to mosques? That may not be possible, neither it may be desirable. We have to be future oriented. We have to be accountable to the citizenry, demanding the development of the country and material prosperity. The premise of August 15 was this break from history and granting equal rights to the people. So this foundational character was present in 1991 law. And the judgment of the Supreme Court itself concurs with it. If I read from the judgment that the Parliament determined that the independence from the colonial rule is a constitutional base for healing the injustice of the past. So that's there. So, but then you cannot entertain such PILs. They open a Pandora's box and they avoid the divide in the country. So this law was made. And now the Supreme Court wants to open a minefield with no constitutional issue at stake. On Friday, last Friday, when the Supreme Court asked the Centre to respond to the plea, it sent a shockwave in all the right-thinking people. In agreeing to examine the law, the court has opened the door for litigation in other places of worship across the country, including Mathura and Varanasi. And that's not a happy thing to do. Narasimha Rao had passed this law to maintain the religious character of places in worship as it was in 1947. After you have got to see, okay, what's done is done, let this be a cut-off date. What happened before that, forget it. This is a starting date. So cut-off date is a starting date for a new development. And the provisions of the law are very clear, declaring the object of the law as an act to prohibit any place of worship and to provide for the maintenance of the character is a very sensible thing to do. And yet the Supreme Court, which accepted this in 1991, today wants to change it. And Section 4.2 says that even if other proceedings were there, they will be continued, but no fresh proceedings can be filed. So why was this filed? As a matter of fact, I like that thing. The law very clearly exempted any place of worship that is an ancient and historical building or an archaeology site or is covered by the ancient monument that shall not be covered by this law. A suit that has been finally settled and disposed of shall not be covered by this law. Any dispute that has been settled by the parties themselves shall not be covered by this law. So, in case there is a historical blunder that can always be there, but to make it an open minefield, battleground, is stupid. Justice Ranjan Gogoi, the Chief Justice, has referred to the law and very correctly said that it manifests the secular values of the Constitution and prohibits retrogression. So, the reopening itself is fraught with danger. Now, why the challenge is there? The advocate Ashwini Upadhyay has challenged the law on the ground that it violates secularism. As I said earlier, that he challenges the date, and then he says prohibits Hindus, Jains, Buddhists from approaching the courts to reclaim their place of worship, which were invaded. Now, what would he say about those 500 masjids in Punjab and maybe thousands of more such masjids in other parts of India, which were converted into houses or temples or gurdwaras? Would they also be returned? Would there be no end to that? At that time, BJP had opposed the law, undeniably. But they had clearly said that the center has no power to legislate on places of pilgrimage or burial grounds, which is under state subject. Perfectly justified. But they forgot that the government had said it was using the residuary powers under entry 97 of the Union list. This is entry 97. These people forget. India is a federal country. And the residuary power of the center is to legislate on subjects which are not in any of the list or on any of the lists. So this law being challenged is actually, it has three implications. A, should PILs continue? Which I clearly say should not. Secondly, should the Supreme Court or any court have a jurisdiction to reopen the settled issues? No. Thirdly, should the Supreme Court, as it has been done in one case, they are directing the state government to do it. In the other state, they are doing it, or they are taking suo motu decision in case of one person was arrested. And the news was there. And the High Court of Punjab and Haryana issued a suo motu notice to the Haryana police to produce that arrested girl, Navjeet or Navdeep or something like that, an activist. Now, that was not justified. If there has been a habeas corpus petition, it would have been justified. Judges per se are not supposed even to have a social get together. So taking suo motu action on the basis of a newspaper report, especially when newspaper reports cannot be depended on for truth and veracity, was not justified. As such, it's high time that the courts and the judicial system takes a look on itself And if they are incompetent to take a look on themselves, if they are incompetent to have self introspection and self control, then it's incumbent on the parliament and the executive to pass a law telling the courts and laying down the parameters for them to do. Let's be clear, no court has a right to be a supra parliament. Ultimate authority is with the parliament. In any democracy, the final authority is not the court of law, it's the parliament. Let's be clear. And it's high time that the Prime Minister moves a law or a constitutional amendment, A, that the original the Prime Minister and the Chief Minister is revived, and that so-called judicial nomination, JIC, is finished off. Judicial appointments must not be made by the judiciary itself, which is happening. Secondly, clear parameters should be laid down where the Supreme Court and the High Courts can act. And they should be told clearly in unambiguous terms that they have no right to be supra-legislative or supra-executive. Their right is to interpret laws, not to be the social, moral guardians. They are not the policeman on duty to watch. Somebody goes to them, they interpret the law, period. More than that, active judicial system would be a disaster for the country, the cultural heritage that India has. It might be okay in some countries, but even in those countries, there has been a carping criticism of this long arm of judiciary, which is like dining with the devil. They say you need a long spoon to dine with the devil, and judiciary is using that long spoon now. Better stop it, or it is a recipe for a breakdown where the judges assume the role what Pakistan army has in Pakistan. And that's a day to be dreaded because you are trading one form, however rotten may be, of democracy with an absolute tyranny of the judiciary. And the tyranny of judiciary is as bad as tyranny of anybody. It's a dictatorship. So let people wake up and let the government wake up to the impending danger. Thank you.